read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Angela Hsu. Angela, you may begin.
Thanks so much. Thank you, everyone, and welcome. I am so thrilled to be introducing three of the most preeminent scholars in the area of Asian American legal history. I'll give a very brief introduction of their more like their day jobs, but the first is Judge Denny Chin. He's been a federal appeals court judge for the Second Circuit for the last 14 years. And previous to that, he was a U.S. district judge for 16 years in the Southern District of New York. We also have Judge Chin's wife, Kathy, who's a recently retired partner from the law firm of Cadwalder, Wickersham, and Taft, and has served on a number of commissions and panels for the city of New York, as well as for the federal courts. And then we also have Professor Thomas Lee, who's a professor of constitutional law, international law, data security, among a whole host of other things at Fordham Law School. And it's my pleasure to be introducing these three very sought after speakers for API Heritage Month. I'm going to start with one question for each of you. When did you start to take an interest in Asian American legal history? We'll start with Judge Chin.
Angela, thank you for the question. It's a complicated question. I'll get into it a little bit more later, but I think in part because of my personal background, I've always been interested generally in the area. But more specifically, Kathy and I and the Asian American Bar Association of New York started doing reenactments of historic cases involving Asian Americans in 2007. And so for 17 years, we've been doing reenactments of these historic cases, unveiling them at the NAPABA convention each year. And we've been repeating them. We have our Vincent Chin reenactment has been done more than 30 times, for example, all over the country and indeed even in Europe. And because of those reenactments, I really developed a passion for the area. And then I think Kathy's going to go next.
Yep. Thank you for the introduction and for the question, Angela. It's true. I probably did not become at all interested in Asian American legal history until after we started doing the reenactments. My background is my father was Nisei, Japanese American. My mother was white. I was born in an army hospital in Frankfurt, Germany, and so really had very little contact with my Asian American roots until fairly late in life. And it really was the reenactments more than anything else that got me interested. And like many Japanese Americans, there were aspects of that history that I was not at all comfortable with. And Denny and I had some of our first disagreements about, so how are we going to present some of these things? And of concern was my dad was a proud Japanese American who was very proud of the Fighting 442nd. One of the first reenactments that Denny and I did together had to do with the draft resistors at Hart Mountain. And I couldn't help but think when we started working on that my father would have been concerned about the path I was taking. So that's a long answer to your question, but it really was the reenactments more than anything else.
And how about you, Professor?
So I've been teaching law since 2002, but I taught general constitutional law and federal courts and civil procedure and international law, and I wrote and researched those subjects. And my first real academic interest in these issues happened right around 2016 when I was writing an article about the natural born citizen provision of the Constitution. I wrote an op-ed about the situation of Ted Cruz and whether he was eligible to be president because his father was a Cuban Canadian citizen and his mother was an American citizen. So I started doing research into that particular provision, the Natural Born Citizen Clause. And of course, the most important, I wouldn't say it involves that clause, but the idea of natural born citizenship. There's a decision called Wong Kim Ark, an 1898 decision. And that was the first time my research interest sort of veered into Asian American legal history, because the story of US citizenship over the majority of the existence of the American Republic was restrictive with respect to non-white populations, and so it was interesting to see that decision at a time where it wasn't expected. I mean, the idea that anyone born on US soil is a US citizen is the one early non-restrictive principle of citizenship that we've recognized under a constitutional system. And so that was my first intellectual interest. And then as a practical matter, when the judge and Kathy, when I got involved with the reenactments, they sort of gave me the opportunity to explore these interests in greater detail. But that was my first encounter with Asian American issues in legal history, even though I am Korean by descent and actually an immigrant myself. So,
Okay. Judge Chen, did you want to
Yep.
start the program?
Yep. So here's what we're going to do. Oh, here we go. I'm going to start first. I have some slides for my presentation. I'm going to talk a little bit about my personal background, as I alluded to earlier, just a little bit about some of the cases I've had over the years, and then a bit on Asian American legal history, some of the cases that we have gotten really interested in. And then Tom's going to offer some perspectives as a con law professor and scholar. And then Kathy will go over some of the activities that our Center on Asian Americans and the Law at Fordham Law School has engaged in. So first, a little bit about my background. This is my grandfather in front of his brownstone in Chinatown. He was an illegal immigrant. He came into this country illegally in 1916, 20 years old. He didn't speak any English, no money. And he had to come in illegally because of the Chinese exclusion laws. He bought a piece of paper pretending to be the son of a US citizen, and that's how he was able to come into the country. And for many years, he worked as a waiter in Chinese restaurants. He went back to China only twice, once in the 1920s when he got married, and once in the 1930s when my father was born. And both times he had to leave his family behind because of the restrictive immigration laws. And yet he could make more money in America as a waiter than he could doing anything in China. He lived in one of those railroad apartments in Chinatown, and there was a single man in each room. And all of them, like my grandfather, they go to the post office every month, buy a money order, and send it home to their families in China. But the immigration laws were finally relaxed, and my grandfather became a US citizen in 1947, naturalized in the Southern District of New York. I think he got naturalized in the courthouse where I am now, because on the back of this certificate, it says sworn to an open court. And in 1947, in the Southern District of New York, there was only one courthouse, what is now the Thurgood Marshall United States Courthouse. And I am, by the way, sitting in chambers once occupied by the great Thurgood Marshall himself. I'm actually today sitting in Brooklyn. I'm hearing some cases in the Eastern District of New York. I had a matter today. But one of the nice things about my designation in the Eastern District is that I've been able to do naturalization ceremonies. I did one, because you don't do them as a circuit judge, you do them as a district judge. I did one here 2 weeks ago. I had 97 people being sworn in as new American citizens from 44 different countries. And I show them my grandfather's naturalization certificate. I have this framed and hanging on the wall in my chambers. And I told them the story of my grandfather and how he came to this country. And because of how hard he worked, he was able to bring us here. This is us in Hong Kong in 1955. That's me sitting in my father's lap with my mother, my sister, and my younger brother. And this is literally us coming to America on the Pan Am Airlines bus in 1956 at the airport in Hong Kong. And you can see the silhouette of my mother off on the right behind the window. And this is my mother's original Chinese passport. The kids didn't get their own passport. They put us into the photo with the mom, but I had a page for me, and this was my Chinese name. And this also shows that we were political refugees. We were admitted to this country under the Refugee Relief Act of 1953, which was a statute passed to help people fleeing from communism. My parents fled China. They met in Hong Kong. Well, and the rest is history. And this is me being sworn in the circuit. My mother was still alive then. She's sitting in the first row with the red scarf. My dad is still alive today. He turns 90 this year. And so I've been really fortunate to have been a federal judge now for almost 30 years. And I've had more than my share of interesting cases. Early on, as a young district judge, I had the Megan's Law case, the sex offender statute case. I ruled that parts of Megan's Law were unconstitutional. This is Governor Pataki signing the New York version of Megan's Law. Megan's Law was in New Jersey. When I held that parts of it were unconstitutional, the Daily News gave me a nickname, Denny the Pervert's Pal Chin. And there's good reason why we have life tenure. If I had had to run for reelection or stand for reappointment, I would have had a difficult time with one of the major New York papers calling me the pervert's pal. I had a case involving the Million Youth March. They had applied for a permit to march in Harlem. The city said no, because there had been some violence the year before. They sued, alleging a violation of their First Amendment rights, and I agreed. And I had the power to order the city of New York to give them a permit. This is a sentence from my decision, which became the New York Times quote of the day. It was pretty cool to have a sentence from my opinion as the New York Times quote of the day. When our son was in high school, by the way, at Stuyvesant High School, he took a debate class and they argued two cases, and both cases turned out to be mine. One was Megan's Law and one was the Million Youth March. He tried to lay low, but when he told the judge that his father was the judge, when he told the teacher that his father was the judge on both cases, she made him argue that I was wrong. I've had a lot of music cases. These are usually copyright cases. The late, great Whitney Houston was sued for copying the words, "clap your hands." Obviously, that case did not last long. You can't copyright common phrases like that. I had a lot of movie cases, and some of these were fun to watch. Some of them, well, it was cruel and unusual punishment. Most of these were also copyright cases. This is a copyright case. Can you copyright the idea or the concept of a stuffed gorilla? So the IP lawyers out there are shaking their heads saying no, and that's correct. You can't copyright the idea of a stuffed gorilla, but you can copyright the expression of a stuffed gorilla. And here I thought the two expressions were too close. There would be confusion, and I issued an injunction to stop the distribution of the copy. And if you're wondering, the copy is on the left. You can see the small red K in the hang tag. This is a Kmart special, and it's sold for $19.99. The original on the right, of course, sold for a lot more money. I have the Naked Cowboy case. I don't know if he's still there, but the Naked Cowboy would stand in the middle of Times Square in his whitey tighties and his cowboy boots and cowboy hat, strumming his guitar. The tourists would come over and take selfies with him and stick dollar bills into his guitar. And a couple of blocks away, the M&M store started running videos of famous New York characters. And they ran one of the blue M&M dressed up like the naked cowboy, but they had not gotten his permission. And so, of course, he sued. He asserted two theories. One was invasion of privacy. I dismissed that theory quickly because here was a guy standing in the middle of Times Square in his underwear. The other claim, however, was a good claim, trademark dilution. He had trademarked his outfit and his name. The implication was that he had endorsed M&Ms when he had not. And so I let that claim proceed. At one point, the court security guys called up and said, we heard the naked cowboy is coming to court. Should we let him up if he's wearing his costume? I said no. I was not going to let him into my courtroom in his whitey tighties. I had the Google Books case, a copyright case, one of the more important copyright cases in recent years. The Tom Brady, the Flakegate case, which was fun. We had this was when I was in the circuit. We had oral argument. I was able to go home and turn on ESPN and listen to all the experts dissecting our questions. Of course, this was a contract case, a collective bargaining labor law case. This case became a Law and Order episode, and I've had several of my cases become Law and Order episodes. Mr. Morales in the front there in the white shirt was convicted of murder in the Bronx when he was 18 years old. And you can see the priest in the back. The priest came forward at one point and said the real murderer had confessed to him, and the real murderer said that Mr. Morales was innocent. Mr. Morales was not there. The real murderer had since died. There was also a legal aid lawyer who wanted to come to court and testify that the real murderer had said the same thing to him. And so, of course, the priest penitent privilege survives death. The attorney-client privilege survives death. The priest, however, was a street priest. The conversation did not take place in a confessional booth. And under the circumstances, the church gave him permission to recharacterize the conversation as a heart-to-heart talk. The lawyer probably was doing something unethical by disclosing what the real murderer had said to him. But in the interest of justice, he felt he had to do that. And after 12 years in prison, Mr. Morales was released as I granted the writ. In this case, these two guys were convicted of murdering a police officer in a shootout on the Grand Concourse in the Bronx. That's the police officer's mother in the back there on the left. She came to court every single day. I sentenced them to, they were convicted by a jury. I sentenced them to life plus 125 years. I was not being vindictive, but certain gun counts carried mandatory, minimum, consecutive sentences. And so I had no choice but to give them life. This was an Afghan warlord, the head of a 1 million-person tribe. He was persuaded somehow to come to the US. And when he got here, they indicted him for importing heroin. And it was a great trial. I learned about cooking, about growing poppy in the fields in Afghanistan, cooking it into heroin. The Taliban helped transport it across the desert, and some of it made its way to the streets of New York City. For better or worse, I'll be known forever for the Madoff case. This is the first time he came to see me entering the courthouse. This was the sentencing. The artists will tell the story. And there was never a point when all the victims stood up. Part of my concern was to really control the courtroom. But this is the way it was. And as you may recall, I sentenced him to 150 years in prison. Why sentence a 71-year-old man to 150 years in prison? Well, I wanted to send the strongest message that I could. And there was so much attention. There was even a coloring book. It was pretty sarcastic. If you're wondering, yes, I'm in the coloring book. At one point, you could buy this on Amazon and color me in. There were 2 movies made about the Madoff case. There was a Netflix documentary. I liked The Wizard of Lies, the Robert De Niro version, because there were 2 courtroom scenes. This is Clem Chung, who played me. He actually used my words that I said in court, some of them. I wasn't too pleased about this choice. You know, he's a little bit older, he's cranky looking. I had been hoping for Daniel Day Kim myself, but it was not to be. And finally, a little bit about Asian American history. We touched upon it earlier. Um, and one of the things that drew me to the area as we were doing these reenactments, we were learning the stories of these people. And they were people with limited resources, laborers. Wang Tim Mark was a cook, you know, in the birthright citizenship case that Tom talked about. Laundrymen, one of the few cases to be taught in con law in law school is Jigwo v. Hopkins, a very important case. Grocers, there were actually a couple of bubonic plague cases. One of them was brought by a grocer. Women accused of being, suspected of being prostitutes. This was the first case, Chai Lung versus Freeman, involving Asian American litigants to go to the Supreme Court. And so many of these cases actually wound up going to the Supreme Court. And the issues that were raised are still important today. The Chai Lung case is certainly relevant to the cases now involving what Texas is doing, for example, as states try to take immigration into their own hands. So one of the ironies of the violence in the recent pandemic was that this, you know, long ignored history of Asian American history suddenly got some attention because people were concerned about what was happening and trying to explore the reasons why. And it was around this time that Tom and I, we had started teaching Asian Americans in the law in 2017, but we wanted to do more. And he and I decided to start a center on Asian Americans in the law. And we got Kathy to help us. Kathy became the chair of our board of advisors. And so more on that later. But the recent violence was unfortunately not the first time Asian Americans were subjected to violence. The Los Angeles massacre of 1871 resulted in 15 Asian American males being hanged. One of them was a 15-year-old boy who had been in the country for only 2 weeks. Several others were shot, so that at least 18 Chinese men were killed in this massacre. In Rock Springs, Wyoming, white railroad workers killed 28 Chinese co-workers. They were concerned that the co-workers were willing to work for less money. They didn't want, I mean, the Chinese workers were willing to work for less money. They wouldn't participate in the strike. And 28 of them were killed in this rioting. Hell's Canyon, Oregon, horse thieves robbed and killed 31, as many as 31, perhaps as many as at least 31, as many as 34 Chinese gold miners, stole their gold, burned down their camps, killed them, and threw their bodies into the Snake River. And by the way, one of the continuing themes in these cases is very little was done in terms of justice. Very, very few people were actually prosecuted and convicted. South Asians in Bellingham, Washington, were driven out of town by mobsters. And in the 1930s, Filipinos, farm workers, were injured as there were rioting for 5 nights, and a 22-year-old farmhand was killed while he was sleeping. And so it wasn't just violence. You know, the fear of the Chinese became politicized. Politicians seized on it. Unions used it to try to rally the masses. And these are political posters from back then. This is actually a washing machine ad. A washing machine company was trying to sell washing machines by alluding to the Chinese Exclusion Act. And of course, a number of Chinese had taken up laundering services. There were actually 3 political cartoons about building a wall. It's not just a recent phrase that we've heard. Here's one, here's another, building the wall, the anti-Chinese wall. to keep out the Chinese. And here's another one that not just the Chinese, but others as well, including Japanese. And this is one of our favorite cases. Ho Ah Kao was a laborer who was arrested for violating an ordinance limiting, trying to limit the number of people living in Chinatown. And his first day, he couldn't pay the $10 fine, so he went to jail. And the first day, the sheriff, you can see the sheriff up in the top, cut off his queue. And if a Chinaman lost his queue, his pigtail, it was a mark of shame, disgrace. And Ho Ah Kao sued. He brought what was essentially an early civil rights case against the sheriff personally, seeking $10,000 in damages from the sheriff. And he won. This is the judge. It's a cartoon mocking the judge for ruling in favor of Ho Ah Kao, Justice Stephen Field. The judge felt that this was a violation of equal protection. And this is before the Laundryman case, so it was an early decision and a win. This is Eureka, California. There were actually 168 communities in the Southwest that kicked out all their Chinese residents in 1885 and 1886. They decided they wanted to get rid of all the Chinese. There were several hundred, and they were driven out of town. And 56 of them got together and sued. And this is actually the first page of the actual complaint. We're able to find the documents. And what's great about this is here is an early class action, long before there was such a thing as Rule 23 of the Federal Rules of Civil Procedure. Here's an effort to hold the city, a municipality, liable for failing to control a rioting mob. And individually, the claims didn't amount to very much, but when you put 56 of them together, it became a more substantial lawsuit. 2 of the 56 were women. One of them, there were blanks that they filled in, and one of them actually put in, "I am a woman." She was proud of the fact that she was a woman. The lawsuit failed, but the fact that they were willing to try was very significant and sent a strong message. I mentioned the bubonic plague cases. In San Francisco in 1900, there was a fear of the bubonic plague. And so the authorities quickly passed 2 resolutions. One was a quarantine. And this is an exhibit from the court file. And the red line shows the quarantine. You can see it all around. And here's a blow up of the top. And you can see that the buildings at 910 and 922 were carved out. Why were they carved out? Well, there were non-Chinese living there. And so they were exempted from the quarantine. The judge relied on this fact to find that indeed the quarantine was targeting the Chinese to drive out the Chinese. The second resolution imposed a vaccination requirement. If you were Chinese and Asiatic by name, the resolution referred to the Chinese and the Asiatic. If you wanted to leave the county and come back, you had to be inoculated with this experimental vaccine. So one of the cases, Obata versus Williamson, were actually 3 Japanese guys who were denied passage on the ferry going from San Francisco to Oakland because they did not have proof of vaccination. And so the stuff is so familiar to us, having gone through the things that we went through the last few years. And ironically, even though the bubonic plague lasted in San Francisco for 3 years or so, only 113 people died, compared to the millions that we saw with the recent COVID-19 pandemic. There were other forms of discrimination. We don't really have time to get into it. The internment of 120,000 Japanese Americans, 2/3 of them US citizens, as they were sent to concentration camps without individualized suspicion, without hearings. This is a case from Houston, the Gulf Coast in the 1980s. After the fall of Saigon, many of the South Vietnamese refugees settled in the Gulf Coast, and many took up fishing and shrimping. The white American fishermen and shrimpers took offense, concerned about the competition. They brought in the Ku Klux Klan to engage in a pattern of violence and intimidation to drive away the Vietnamese fishermen. The Southern Poverty Law Center in Alabama heard about this, and they came in and they brought a civil suit on behalf of the Vietnamese fishermen, asserting not just civil rights claims, but also, for example, an antitrust claim, restraint of trade. And there was a hearing, a preliminary injunction motion. The Vietnamese fishermen won. The court issued an injunction enjoining the Ku Klux Klan from engaging in its campaign of violence and intimidation. And finally, this is the iconic Vincent Chin case. Vincent Chin was out celebrating with friends. He was to be married the following week. They were at a club outside of Detroit. They got into an argument, and two auto workers beat him up with a bat, and he died a couple of days later. And for beating someone to death with a bat, the two guys pleaded guilty to manslaughter. The prosecution didn't even show up at the sentencing. That was not uncommon back then in that part of the country. The judge
Judge, you you froze right after the judge. I don't know if IT can fix that or.
Yes, unfortunately, he's in a very low or not a good Wi-Fi area, so
Okay.
moved to Cincinnati.
that's why he comes back in.
Okay. I think the judge was talking about the Vincent Chin trial. The judge essentially gave them a slap on the wrists, and no.
Okay, sorry.
Oh.
My connection died. I'm almost done anyway. So in any event, Michael, you have to give me back control, or I only have two more slides, but then I have Kathy's slides.
Denny, you were talking about the sentence given
Yeah.
to Vincent Chin's killers.
Yeah. Michael's giving me back control of the screen. So I'm not quite sure where I left off. They got 3 years probation and a $3,000 fine, and eventually a federal civil rights case was brought. There was a conviction, but that was overturned, and ultimately they were acquitted, and they never served a day of prison for killing Vincent Chin, beating him to death with a bat. Michael, I can't seem to move the slides. Oh, here we go. All right, I'm almost done. So with this background, these stories, these cases are so rich, and they tell us so much. And that's why, we've fallen in love with the area. During the pandemic, this artist came up with these beautiful posters. And education is a big part of what we're trying to do. And with that, I will turn it over to Professor Lee.
Hi, everyone. I'm going to be relatively brief. And what I'm going to talk about is the judge has covered sort of a range of historical cases dating back to the 1870s. And I just want to make a comment about how relevant they still are. So there's a case that we teach that the judge didn't mention, Chilung versus Freeman, which involved a California law giving the local port inspector a great deal of discretion for not allowing to land and charging monies with respect to Chinese women that he had ascertained were sex workers. And so the issue there was, well, to what extent does the state of California have the right under our constitutional scheme to regulate immigration in this way versus the federal government? And the Supreme Court held that the local regulations, the state laws, were unconstitutional. Now, you could see that that case is directly relevant to what's going on right now in Texas and the legislation there, where the governor and the local authorities are pleading self-defense as a reason for additional measures with regards to migrants that beyond what federal law requires. And so that case is still cited, and it's fascinating to sort of see that that particular issue is still a very important one. Another example of a case like this, the judge mentioned the haircut ordinance. So the haircut ordinance was another case from the 1870s involving a law that San Francisco had enacted that was clearly discriminatory against Chinese men, because it was customary to prove fealty to the Manchu emperor for grown men to grow the queue. And the haircut ordinance purportedly for sanitary and other reasons required inmates to have their haircut to within 1 inch of the scalp. Now, these issues about laws that are enacted with regards to haircuts and hair regulations for purportedly neutral reasons, those are very important issues today. For example, there's litigation involving Sikh men who joined the United States military and the extent to which they are required to cut their hair to comply with general haircut regulations. So that's another example of a historical case that's relevant today. The judge mentioned the bubonic plague cases. Again, the bubonic plague, as we now know, and as was strongly suspected at the time, is transmitted by rats, but there was a prevailing view that the Chinese were particularly susceptible, were carriers, and regulations were enacted to quarantine just the Chinese. And that map the judge showed is one of the starkest. I'm talking to a bunch of lawyers, so I'm sure there's a bunch of trial lawyers out there, but you're looking for that aha exhibit. And you put it up on the PowerPoint right now, and you're like, okay, we're going to win this, because there's no way you could justify a quarantine that carves out these two addresses that happen to be white-owned residences or businesses. And so that's another example of something that we take from history that is still relevant today. The fourth example I'll use is the judge didn't mention this, but there's a case called Thind, and the issue there was under the citizenship statutes, you had to be a free white person or someone of African descent to qualify to be naturalized as a U.S. citizen. And the individual in that case, Thind, the Romanized form of his name today would be Singh, but he was a Sikh who had served in the United States Army, and the question the Supreme Court decided was whether he qualified as a free white person. The lawyers argued that he's actually sort of a high caste Hindu, and so therefore they were Aryan, and so they're Aryan. That means white under a scientific definition of the word white, as the Supreme Court itself had indicated in an earlier case. And so one aspect of studying these, you can, and again, I'm talking to a bunch of lawyers, so you can understand the legal instinct in making these types of arguments. Fast forward to 2016-17, the judge and I teach a number of cases called the Mavney cases involving foreign citizens who had been recruited to serve in the United States for certain militarily essential skills, and once there were suspicions of possible intelligence from foreign nations and espionage, they were subject to additional scrutiny, even though some of them had already become U.S. citizens, and the district judge in that case struck down the governmental additional national screening on the basis of their foreign origin as against the Equal Protection Clause. So one of the starkest aspects of this is we learn this history, and then we sort of see how these principles are still at play in modern cases in ways that are important and illuminating. So that's all I have to say.
We're going to move to Kathy then to talk about our center.
Okay, yeah, there's the slide. So I'm here just to tell you a little bit about the Center on Asian Americans in the Law at Fordham Law School. As you've already heard, Tom and Denny have been teaching a course on Asian Americans in the law since 2016 or 2017. But during the pandemic, with all the anti-Asian violence, you know, like many of us, they thought there really must be something more that we can do. And so sometime during the pandemic, they hit on the idea of starting a center at Fordham Law School. And by 2022, they had persuaded Fordham to start such a center. The idea was to open a center that would be a hub for scholarship into API legal issues, to educate students, lawyers, the public, to try to generate interest in some of these stories that you have heard. And might as well turn to the next slide, Denny. And also just to collaborate with other organizations on getting the word out, on publicizing these stories, and to try to put a human face to the people who were being pushed in front of subway trains and beat up on the street. So with that kind of idea in mind, they started the center in 2022. And since then, the course has really taken off. I mean, it was always of interest to at least Asian American students at the big law schools. In more recent years, many more people have gotten interested in it, including non-Asian students. So next slide. And these are the law schools currently who are teaching or have agreed to teach the course. And there are 14 of them at this point. And they are all using essentially the materials that Denny and Tom have developed over the years, including some of the slides that you have seen today. They are also currently making arrangements to publish a casebook, which will include, again, a lot of these stories and many of these images. The course has already started turning out its own scholars into Asian American legal history. 6 of Denny and Tom's students have been able to get their student papers prepared for their class, accepted for publication in legal journals, and 2 of them have won the Matsui writing competition, which carries a $5,000 prize. So there's a number of activities of the center that I just wanted to tell you about quickly. One of these is the annual teaching workshop. The first one was held in 2022 in July at Fordham. Here are some pictures from the teaching workshop. The idea was to bring together people who might be interested in teaching the course, give them a few tips. Increasingly, it has included the opportunity for people who have actually taught the course already to exchange ideas about how to do it better. And this next series of slides has to do with another annual activity of the center, and that is our fall symposium on Asian Americans in the law. Typically, the event will start with some Asian American legal history, very similar to what you saw at the beginning of this presentation. It's then followed up with a panel, because as Tom specifically mentioned, these issues that are highlighted in this legal history still resonate today. So what the center does is we combine these, the legal history, the cases from the 1800s, with a discussion with people who are currently involved in these same kind of issues. So you've just seen some of the slides from 2022. These are from 2023. And in this fall, we will be having a symposium on espionage and AEPIs. And I believe it's scheduled for November 14th of this year. So far, we've got a couple of panelists. One of them will be the lawyer for Wen-Ho Lee. Another will be a professor who was actually accused of espionage. And I think that's actually a picture of Brian's son, very young, in the lower right-hand corner. So those are some of our annual events. Just to turn to some other frequent activities of the center, we often do reenactments at Fordham and at other law schools. These pictures are all from reenactments with Fordham's Apalsa, and this is from 2023. Alice in Chinatown. And this is our most recent reenactment with Fordham's Apalsa, a history of hostility and violence against AEPIs. And again, many of the cases that you heard Denny speak about earlier are covered in this reenactment. I mean, one of the other things that the center does is we screen films. So again, this is Chol Soo Lee, Alice in Chinatown. This is a screening of the movie. Then again, what we do is we show the movie and then we have a discussion afterwards. This particular screening was of a movie that is, I guess, near and dear to our hearts because Denny is actually in it portrayed by a famous actor. And they use his naturalization speech. And they actually, in the movie, put up an image of his grandfather's certificate, which Denny showed you earlier. This movie is not, I think, being circulated at this point. It can't be streamed, but it did have its premiere at the film festival, the Tribeca Film Festival. Here's another screening, All We Could Carry in Days of Waiting, about the internment camps. And again, there was a panel afterwards, which included, I believe, one of the directors of the movie who zoomed in to talk about it. And in addition to screenings, here's another one, The Long March, and Professor Lee with a Filipino member of the naval branch, I think, possibly.
He's a Navy lawyer, Captain Uzone, so he's a deputy JAG for the Navy.
A deputy JAG, who talked with Tom about the experience of Filipinos. And throughout the year, we have panels. And this is the most recent one, a conversation with 3 federal judges. You see them there on the left, Michael Park, Kyo Matsumoto, and Pam Chen, talking with Denny and Tom at the panel. So we're still a very young organization. We're pretty much brand new. One of our current goals is to try to better reach out to a younger audience. To date, most of our audiences for reenactments and for these panels have been other lawyers, just members of the general public who are all adults. But we've learned that younger people, middle school students, high school students, can also get very involved in things like our reenactments. And it's actually a great way to teach civic education, right? I mean, something that is sadly lacking in many of our schools today. So we are trying to remedy that with our reenactments and working with other organizations to get these stories out there. Ideas are welcome for how we can do that, and ideas for other directions that the center can take are also welcome. And of course, everyone is welcome to our various screenings, reenactments, and symposiums. That's it.
That's great. Yeah, thank you all so much for the work that you do. Before we go to Q&A, I'm going to go ahead and give the CLE code. The CLE code for today is SS, that's Seyfarth shot SS 0528. Okay, so if anyone has any questions in the remaining time, we have about 10 minutes left. Please drop them in the Q&A or in the chat, and I will pick them up. I want to start with a question about this, about the alien land laws that are sort of popping up everywhere now. It seems like recently Georgia passed one as well. Can you all, one of you, or all of you, kind of comment on what you think of these alien land laws, kind of what relationship they have to the Asian American legal history that you study and teach?
So Angela, if I may, that's an excellent question, and the judge can add to my comments. We actually teach a case, Oyama, which is a 1948 case involving California's alien non-citizen land laws, which was enacted particularly to act upon Japanese farmers, right? So the Asian American history is a critical part of that. And the lead case so far in the 11th Circuit actually preliminarily enjoined the effect of the land law in Florida. And that's interesting because in some sense, the alien land laws, the Supreme Court cases did not firmly foreclose their constitutionality. To some extent, there's a question of state power over land and the common law tradition. At the same time, and I haven't been following the cases closely enough, the 11th Circuit in their initial opinion focused a lot on preemption logic, that the federal laws are really taking care of these concerns about national security, and so the states are overreaching because of that orientation, which I think is promising, because that's probably the best argument that could be made, and so you try to walk away from these arguments that focus on the state's traditional sovereign control over property within their borders and these Supreme Court precedents. So I think that was a pretty smart play by the lawyers in litigating this case. But that is, I could have used that as my fifth example of a situation in which the historical antecedents are being replayed and as significant as they were when they were first litigated, nearly 8 decades ago.
We have a reenactment about the Oyama case. There's also a powerful story there about the family. But in terms of the relevance to today, there were two issues. One was the broader issue of whether these alien land laws were constitutional, and the Supreme Court ducked that question. The Supreme Court struck down the law, but on the narrower approach of the impact on the U.S.-born son. The father, Oyama, had bought the property, 6 acres of land near San Diego, or maybe it was 8 acres, and put it in the name of his son. And there were certain presumptions, and he couldn't put it in his own name because the statute said he couldn't own the land. And when it got up to the Supreme Court ruled on the narrower approach that it was unconstitutional as applied to the U.S.-born son. So who knows what will happen with the current cases? I think it would have to involve a broader approach, and we'll have to see what happened. But again, issues raised that are still important today, compelling stories. There were folks who were drafted and went off, Japanese American men who went off and fought while their property was being escheated. The word is escheat. It's a verb you may hear in law school and never hear from again. But in this case, that's where the escheat was applied.
And so in the remaining time, I have one more question for you all. In the cases that you've studied, are there common threads between the times in which the litigants have succeeded as opposed to, not, have failed to get redress from the courts.
Yeah, that's a great question. In many of these cases, surprisingly, some of the older cases, the Asian immigrants were extremely well represented. They pooled money and paid for blue chip lawyers to litigate their cases, who were overwhelmingly older Caucasian males. And so generally, lawyering certainly helps. The other, and now I'm sort of generalizing, but it seems to me that the most successful cases involved instances where either discretion or the disparate impact were so stark, right? It really was very difficult for you to accept a plausible counter argument as to how this was consistent with the rule of law. It was almost staring at you in the face. And I think it's a lot harder nowadays because part of it is society has advanced. We're not going to see those kinds of like very clear cases anymore, but they might still be out there, right? So the haircut example is an interesting one because I think for many people didn't realize that haircuts were sort of a contested area, a domain of structural racism or whatever, what have you. I mean, it probably didn't occur to a lot of people, and yet it was, right? And if you'd looked at these old cases, you would have seen that it was a contested domain, and maybe there are others out there that we're not aware of that will come up, and the history helps illuminate them. Certainly.
I would just add a couple of things. One is back then there were no such things as public interest lawyers or pro bono lawyers or big firms doing pro bono services. And so a lot of it was, the Laundrymen's Association, the Merchants Associations pooling their resources and chipping in. I think to some extent there may have been, like the railroads needed the Chinese workers, and so they may have helped pay for some of it. These were lawyers who usually represented railroads and banks. The 22 Liu Chinese women case, it's quite possible that the person who paid for the lawyering was a trafficker who was trying to protect his investment. Because there was a suspicion that these women were brought over here. They were traveling alone. They were Chinese. They must have been brought over to be prostitutes. And why? How could they afford this really good lawyer who was a former judge, their lawyer? And the suspicion is that this merchant was protecting his investment. And some of the really, Tom used the word stark. Some of the discrimination was so obvious and so blatant. To have a resolution that's entitled Chinese and Asiatics, or is so clearly targeting a group based on race. But there were also lots. Hard to prove those cases. In California for a while, there was a statute that said that if you were Black or Chinese, you could not testify against a white person. And so that made it hard to convict anyone, because unless you had a white witness who was willing to come forward and testify against someone else, you were out of luck if you were a Chinese victim.
No, and in our class, we sort of, one of the things we do when we teach these classes are to say, well, what's sort of the argument that a testimonial rule like that has some plausible justification other than something that's sort of like a stark instantiation of racism or what have you, of stereotypes, right? And so it's very interesting to see our students turn these issues over.
Great, thank you. There was a question that Professor Lee had answered. Someone who was asking about recordings of the reenactments, and it looks like they're available on YouTube. Would just sort of search for the center or reenactments? Where is that how people would find them?
The Albany, the Asian American Bar Association of New York, has a website. If you Google trial reenactments Albany, you'll find it. that website lists a lot, we now have 15 reenactments, and there are some links provided to some videos and when Kathy was at Cadwalader, they videotaped a lot of our reenactments. And over the years, some other recordings have been made. And so they are available in some places and some are available on YouTube. They are 1 hour theatrical presentations. A number of law firms have been doing them as diversity events. And when we do these things, sometimes we work with the law firm, sometimes they do it on their own. But we recommend that you get it's not just lawyers. You put someone from accounting, a paralegal. You can make give the head of the firm a role as a Supreme Court justice. Kathy Kroll, who was the great actor who played the Grand Dragon?
The chief of records, our record administrative guy. Turns out he had done summer stock theater at one point. He made a great Grand Dragon of the Ku Klux Klan.
Awesome. That's great. Well, this concludes our program today. Thank you all so much. This was such an informative and interesting talk for Asian American Heritage Month. And yeah, that's what we've got. Thank you so much.
Thank you.
Thank you. Thanks. Thanks, Angela. Okay.